You're 19 years old. You live in Massachusetts. You want to buy a handgun for self-defense. But Massachusetts law says you can't get a license until you're 21. You can vote, you can serve on a jury, you can join the military and carry an M4 rifle in combat, but you can't have a handgun license in your home state. That's the law in Massachusetts. And on March 2nd, 2026, the Massachusetts Supreme Judicial Court heard arguments about whether that law is constitutional. The case is Commonwealth versus Thomson. Thomson is a young adult who challenged the age restriction. His lawyers argued that the Second Amendment protects adults, period. And 18 to 20-year-olds are adults. The state can't strip their gun rights just because of age. The state argued young people are impulsive and dangerous. Age restrictions serve public safety, and they're constitutional. The court heard both sides, and now we wait for a decision. If Thomson wins, 18 to 20-year-olds in Massachusetts get handgun licenses. If he loses, the age restriction stands. And this case matters beyond Massachusetts, because if a state Supreme Court strikes down an age restriction, it creates pressure on other states to do the same. You need to understand what happened and what's at stake. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal affects young adults in Massachusetts and across the country who have been told they're too young to exercise their Second Amendment rights. State Supreme Courts are now grappling with this issue after federal courts struck down similar laws. Hit that subscribe button right now, because when the Massachusetts court rules, you need to know what it means immediately. Here's what happened and why it matters. Massachusetts law prohibits anyone under 21 from obtaining a license to carry a handgun. You can own a rifle or shotgun at 18, but handguns require a license. And you can't get that license until you're 21. Thomson is a Massachusetts resident who turned 18 and applied for a handgun license. The state denied his application solely because of his age. Thomson sued. He argued the age restriction violates the Second Amendment. His case made it to the Massachusetts Supreme Judicial Court, the highest court in the state. And on March 2nd, 2026, the court heard oral arguments. This case is significant because it's a state court addressing a Second Amendment issue. Most gun rights cases go through federal courts, but this one is in state court. Why does that matter? Because state Supreme Courts can interpret their state constitutions independently. Massachusetts has its own constitution with its own rights provisions, and state courts can provide more protection for rights than the federal constitution requires. So even if federal courts upheld an age restriction, a state court could strike it down under state law. That's what Thomson is arguing. He says the Massachusetts Constitution, read in light of the Second Amendment and Bruen, protects his right to get a handgun license. Now let's talk about the arguments, because the oral arguments give us clues about how the court will rule. Thomson's lawyer argued that 18 to 20-year-olds are adults under the law. They have constitutional rights, voting, free speech, due process. Gun rights are no different. Historically, once you were an adult, you had full gun rights. There was no separate category of second-class adults who had fewer rights. Colonial militias included 18-year-olds. Young adults owned and carried guns. The age 21 threshold for handguns is a modern invention with no historical foundation. The state's lawyer argued that young adults are different. Their brains aren't fully developed. They're more impulsive. They're more likely to commit crimes. Studies show 18 to 20-year-olds have higher rates of gun violence than older adults. So restricting their access to handguns serves a compelling public safety interest. The age restriction is reasonable and constitutional. The justices asked tough questions of both sides. One justice asked Thomson's lawyer, "But doesn't the state have an interest in preventing impulsive young people from having handguns?" The lawyer said yes, but that interest doesn't override constitutional rights. You can't strip rights from an entire age group just because some of them might be irresponsible. Another justice asked the state's lawyer, "Where's the historical support for age 21 as a cutoff?" The state pointed to some colonial laws that set minimum ages for militia service or bearing arms, but the lawyer couldn't identify a clear historical tradition of prohibiting adults under 21 from owning handguns. That's a problem for the state. Because under Bruen, gun laws need historical analogs, and the state doesn't have strong ones. If you're finding this helpful so far, imagine what you'll learn in my next video where I compare the Thomson case to the federal Worth versus Jacobson case and explain why state courts might rule differently than federal courts on the same issue. Subscribe right now so you don't miss it. Now let's talk about how this case fits into the broader legal landscape. Earlier we discussed Worth versus Jacobson, a federal case where the Eighth Circuit struck down Minnesota's age restriction on carry permits. The Supreme Court denied cert, letting that decision stand. So in the Eighth Circuit, 18 to 20-year-olds can get carry permits. But Massachusetts is in the First Circuit, not the Eighth. The First Circuit hasn't ruled on this issue yet. And even if they had, state courts aren't bound by federal circuit court decisions. State courts follow Supreme Court precedent, but not circuit court precedent. So Thomson's case is independent. The Massachusetts court will apply its own analysis, but they'll definitely be aware of what the Eighth Circuit did in Worth. If a federal court found age restrictions unconstitutional, a state court might follow that reasoning. Now, quick legal note. This is educational information, not legal advice. If you're under 21 in Massachusetts and you're thinking about applying for a handgun license, the law is still in effect. The court hasn't ruled yet. Wait for the decision before taking action. Consult with a Massachusetts firearms attorney about your specific situation. Let me give you real-world examples of why this matters. Imagine a 19-year-old woman named Emily. Emily lives in Boston. She's a college student. She walks home from campus late at night. She's been followed. She's scared. Emily wants a handgun for self-defense. She's an adult. She's responsible. She took a firearms safety course, but Massachusetts law says no. She has to wait until she's 21. Emily feels helpless. She can't protect herself because the state decided she's too young. That's what this case is about. If Thomson wins, Emily can apply for a license. If he loses, she's stuck waiting. Now imagine a different scenario. Imagine a 20-year-old man named Jake. Jake lives in western Massachusetts. He works on a farm. He wants a handgun for dealing with predators and for self-defense in a rural area where police response times are long. Jake can own a rifle. That's fine. But he wants a handgun because it's more practical to carry while working. The state says no. Jake is frustrated. He says, I'm old enough to own a rifle, but not a handgun? What's the difference? The state's answer is handguns are more dangerous because they're concealable, but Jake says that doesn't make sense. A rifle is more powerful. If the state trusts me with a rifle, why not a handgun? That's the inconsistency. And that's what Thomson's lawyers are arguing. The law is arbitrary. It distinguishes between adults based on age for no good reason. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now let's talk about what the Massachusetts court will consider. They'll apply the Bruen test. Is there a historical tradition of age restrictions for adults? If not, the restriction is unconstitutional. The state will argue there's a tradition of setting minimum ages for certain rights. Voting used to require being 21. Drinking still requires being 21. So age restrictions are permissible. But Thomson's lawyers will say gun rights are different. The Second Amendment specifically protects arms. And historically, once you were an adult, you had gun rights. The voting and drinking examples are about privileges, not constitutional rights. The court will have to decide which side is right. And that decision will be binding throughout Massachusetts. Now let's talk about the implications if Thomson wins. If the court strikes down the age restriction, Massachusetts will have to issue handgun licenses to 18 to 20-year-olds who qualify. That means passing the background check, completing the training, and meeting all other requirements. The only barrier that falls is age. Gun control groups will be furious. They'll say the court is putting guns in the hands of immature young people. But gun rights groups will celebrate. They'll say the court is finally recognizing that adults have rights regardless of age. And here's the bigger picture. If Massachusetts strikes down its age restriction, other states will take notice. Connecticut has a 21 age requirement. So does New York, New Jersey, Illinois, California, Hawaii, and others. If a state Supreme Court in Massachusetts says 21 is unconstitutional, those other states become vulnerable. Gun rights groups will file challenges using the Massachusetts decision as precedent. And those cases will cite both Worth from the federal system and Thomson from the state system. The momentum is building. Age restrictions are under attack. And they're losing. Now let's talk about what happens if Thomson loses. If the Massachusetts court upholds the age restriction, young adults in Massachusetts are stuck. They have to wait until 21. And other states with age restrictions will feel emboldened. They'll point to the Massachusetts decision and say, see, even after Bruen, age restrictions are constitutional. That would slow down the movement to strike down these laws, but it wouldn't stop it, because Worth already created federal precedent in the Eighth Circuit, and other federal circuits are considering similar cases. So even if Massachusetts upholds the ban, the broader trend is towards striking them down. Let me give you another scenario. Imagine a guy named Tom. Tom is 18. He lives in Springfield, Massachusetts. He works as a security guard. His employer requires him to be armed, but Massachusetts law says Tom can't get a handgun license, so Tom can't take the job. He loses income. He loses opportunity, all because the state says he's too young. If Thomson wins, Tom can get the license and take the job. If Thomson loses, Tom is out of luck. That's a real consequence. This isn't just about principle, it's about people's livelihoods and safety. Now let's talk about the timeline for the decision. The oral arguments happened on March the 2nd, 2026. State Supreme Courts usually issue decisions within a few months of oral arguments, so we're probably looking at a decision by June or July 2026. When the decision comes down, it will be binding immediately. If the court strikes down the law, Massachusetts has to start issuing licenses to 18 to 20-year-olds right away. No delay, no phase-in period. The law is unconstitutional, so it's gone. This information could literally determine whether you can get a handgun license at 19 if you live in Massachusetts. Subscribe now because my next video will analyze the Massachusetts decision the day it's released and explain exactly how to apply for a license if you're under 21. Hit that subscribe button. Now let's talk about the political context. Massachusetts is a blue state. The legislature is controlled by Democrats. The governor is a Democrat. They support gun control. The age restriction was passed as part of a broader gun control package. The state views it as a reasonable safety measure, but gun rights advocates see it as discrimination. They say you can't treat young adults as second-class citizens just because of their age. The political divide is stark, and it mirrors the national divide on guns. But here's the thing. Courts don't care about politics. They care about the Constitution. And if the Constitution protects 18 to 20-year-olds' gun rights, the court has to enforce that, even if the legislature disagrees. That's how the system works. Now let's talk about enforcement. If the court strikes down the age restriction, how will it be enforced? The Massachusetts Licensing Authority will have to update their application process. Right now, if you're under 21 and you apply for a handgun license, the system automatically denies you. That will have to change. The system will process applications from 18 to 20-year-olds, the same as applications from people over 21. Background checks, training requirements, everything else stays the same. The only thing that changes is age is no longer a disqualifier. Gun shops will need to be ready. They'll see more young customers. They'll need to make sure their staff understands the new law. And gun rights groups will monitor compliance. If any licensing authority tries to slow walk applications from young adults or create new barriers, lawsuits will follow. The court's decision will be enforced aggressively. Let me give you one more scenario. Imagine a woman named Lisa. Lisa is 20. She lives in Cambridge. She's politically liberal. She supports most gun control measures, but she wants a handgun for self-defense. She's been the victim of an attempted assault. She doesn't feel safe. Lisa applies for a license. If the age restriction stands, she's denied. Lisa is conflicted. She understands the public safety argument, but she also feels like she's being treated unfairly. She's an adult. She should be able to make this decision for herself. If Thomson wins, Lisa gets her license, and maybe that changes her perspective on gun rights. Maybe she realizes that gun control laws, even ones passed with good intentions, can hurt people like her. That's the human side of this case. It's not just abstract legal principles, it's real people whose safety and rights are at stake. Now let's talk about the historical analysis in more detail because this is central to the case. Thomson's lawyers will point to evidence that young adults owned and carried guns throughout American history. Militias included 18-year-olds. Some states had minimum ages of 16 or 18 for militia service. Once you hit that age, you were expected to be armed and ready. There's no evidence of laws prohibiting 18 to 20-year-olds from owning handguns, specifically. Handguns were common, and young adults used them. The age 21 threshold is a modern invention. It started appearing in the 1960s and 1970s as part of the Gun Control Act and subsequent state laws, but that's not historical tradition under Bruen. That's recent policy, and recent policy doesn't count. The state will argue that modern understanding of brain development justifies the age restriction. We know now that young people are impulsive in ways that 18th century lawmakers didn't understand, so we can adopt stricter rules to account for that knowledge. But Thomson's lawyers will say, that's not how Bruen works. You can't justify a gun law by pointing to modern science or policy arguments. You need historical tradition, and the state doesn't have it. Look, I spend hours every week following state Supreme Court cases, reading briefs, and analyzing oral arguments, so you understand what's happening in state courts, not just federal courts. The least you can do is subscribe to make sure you never miss state-level gun rights victories that expand your freedoms. Subscribe right now. And if you found this helpful, share it with every young adult in Massachusetts who's been told they are too young to exercise their Second Amendment rights. They need to know this case could change everything for them. Spread the word. Remember, this is educational information based on the Commonwealth versus Thomson case in Massachusetts. It is not legal advice for your specific situation. Massachusetts law still prohibits handgun licenses for people under 21. The court hasn't ruled yet. Do not violate the law based on oral arguments. Always consult with a Massachusetts firearms attorney before taking action. Stay informed. Watch for the decision. And understand that this case is part of a nationwide movement to strike down age restrictions on gun rights. Whether it's federal courts or state courts, the message is the same. Adults are adults, and 18 to 20-year-olds have Second Amendment rights. This is the fight, and we're winning. One case at a time.